Good afternoon, everybody. This is Samantha with the law offices of Samantha Wolfe, and I'm here this afternoon for our next installment of Partnering with the Pros. For those of you that have watched our videos before, we try to feature those professionals in our community that work with our office and with our clients to offer services that maybe our office does not offer or to enhance the services that our office can offer. And so I'm excited today for a couple of reasons. Today I have Matt Berger. Matt is a regional wealth manager with F&M Trust. And I'm excited because Matt's here. I know Matt personally because we actually went to the same high school and graduated a couple years apart. So I've known Matt for years. So we were able to reconnect professionally, and we just kind of realized that there were services that our office offered and then services that F&M offered that worked really well together. And so I asked Matt if he'd be willing to do the next installment of our Partnering with the Pros. So I'm excited to talk to Matt today. Thanks for being here, Matt. Welcome to our Partnering with the Pros seminars.
Thank you much, Samantha. Great to be on here with you.
Yes. So we had lunch. Oh, goodness, it's probably been a couple of months now. And our lunch was fantastic. We caught up on all the old, people we knew, all of those connections.
Yes.
But during the course of our conversation, we started talking about F&M and the services that you guys offer there. And when we were talking about it, I was expressing that so often we have clients that maybe their family members aren't individuals who they can really involve in their estate planning process. They might want to do some trusts, but they don't know who to name as the trustee. And so you and I got into a very fun discussion about the services that F&M offers. So the first question I'm going to toss your way is explain to me a little bit about the role that F&M can have in estate planning.
Absolutely. So, we get involved a lot of times with a client relationship early on when they're just, attempting to save money, getting started and just managing investments. And through that process, a lot of times with our onboarding and our original interview that we do with clients, we're digging in and asking about those legal documents. We want to make sure that you have done an up-to-date will, or if it's been a while, have you had an attorney review it? Want to make sure you have power of attorney documents in place, a medical directive. So that's part of our normal onboarding to kind of get involved and ask some estate planning questions.
Why does F&M care if you have estate planning documents?
So as a wealth management shop, our responsibility, and we've been a trust company really before we had lending power. So over 115 years, we've been offering trust services. The basis of that is acting in the best interest of our customers. So we view any recommendation we make has to tie in all the different aspects of your life, not just your financial goals. So we want to make sure that, not only are we doing the right things with your investments, but do you have all those other elements of your financial world kind of in order as we start building that plan out
Right.
for you?
And I think too, what struck me when you told me that is that F&M really does do a great job of making sure that their clients are in the position that will allow them to maximize everything. And you can't do that unless you have those good estate planning documents in place. So on the estate planning for the legal side, I appreciate that you guys are asking clients that and making sure that they do have those documents in place, because so often we have emergencies where we need those documents in order to be able to act on behalf or in the best interest of our client.
For sure. And, I forget what the exact statistic is. I think it's something like 40% of trusts that are drawn up never get funded, something like that. And a lot of times those are
Yes,
just mistakes where your investment manager, your investment professional, and your attorney are not on the same page, and you don't update beneficiary
right.
designations and things like that. And the whole plan falls through the cracks then.
Absolutely. Yeah, you're right. From a legal perspective, too often I see clients come in with the trust that they have and it's not funded. It's just sitting there empty. And an unfunded trust really isn't doing much for our clients, because you might use a trust to avoid probate. You might use a trust for long-term care planning, but unless you actually transfer the assets into the trust, you're getting no benefit from that legal document.
Absolutely. And I'll say kind of one of the big advantages of our shop. Like I said, we started as a trust company. That's kind of the fundamental backbone of our department. But I send all of our new wealth advisors to the American Bankers Association to get a certified trust financial advisor designation. So really kind of the estate planning
Right.
piece is the fundamental piece of how we deliver our advice, as opposed to say maybe an investment broker or someone in the insurance world where they're more, looking to place those products and maybe the estate planning is kind of on the back burner.
And when you say that F&M started as a trust company, maybe some of our clients don't know what that means. What does that mean when you say that you guys started as a trust
Sure.
company?
So what a trust company does is we are a corporate fiduciary. So what that means is we are able to act in a number of fiduciary roles, whether that is being trustee of a trust, guardianship of a minor child. We could also be agent or executor if someone would desire with their will and through the probate process. But two services that we continue to offer that a lot of our competitors have backed away from, we will still be financial power of attorney for a customer. So, if your
That's
family isn't
wonderful.
local or you don't have someone who can be your advocate in that situation, one of the big things that we see now in the banking industry are elderly folks in our community being taken advantage of, either by family members
Mhm.
or friends or other people that live near them. So we're able to get in there and again, we have that fiduciary responsibility so we can act in the best interest of those customers. And we will also act as special needs trustee, which is another area that's kind of fraught with some, we'll call it legal, just
Mhm.
issues that you can have
Yes.
acting as trustee. Obstacles is the
Obstacles.
word we're looking
Yes.
for. Yeah. Yeah. So we will still act in those
Yes.
capacities.
Explain to me when you say fiduciary responsibility, because I feel like in the legal community, we throw that
Correct.
around a lot. What does it mean when you say a fiduciary
Sure. So the word
responsibility?
fiduciary, what it truly means is that you have to act in the best interest of another person. And I think, if I get the history right, you're going back to really kind of the dark ages is where trusts came from,
Yes.
where, hey, I'm going to go fight in the Middle East. I'm going to leave someone in charge of my kingdom, right? But that person has to act in my best
Right.
interest, not for their own interests. So it's something we take very seriously,
Mhm.
that we have to put ourselves in the shoes of the person we're managing the trust for, or the beneficiary, or whoever we're acting on their behalf, to ensure we're making decisions that benefit them, not benefiting F&M Trust or ourselves individually.
That's wonderful because I'm working with a lot of families where they might have a child that could serve in that position, whether it be trustee or agent. But the concern the parent has, is maybe there's financial concerns that the child has, or maybe there's a situation that the child is in which we aren't sure. We hope that the child's going to be doing what's in the best interest of mom or dad. But when you look at someone or an institution like F&M, it kind of takes all of that out of the way and makes it so that you really are just acting in the best interest of the
Absolutely. And,
client.
and I'll even give you a personal example. So I view another reason to do that is
Mhm.
just not burdening those family members with some of those responsibilities. So in my wife, in my
Right.
will, something happened to both of us. We have a young son. He's going to be turning 4 years
Mhm.
old here in a month.
Mhm.
So what would happen to him? So we've talked with my sister. Her and her husband would raise my son. But then we have all the
Mhm.
insurance money and the retirement funds, and if our house was
Sure.
sold. So I
Mhm.
have all that going into a trust because I viewed that as a huge burden to lay on my sister, to say, hey, not only do I want you to raise my son, but also don't screw up with his inheritance, right? Here's all this money. And
Right. Here's this money
yeah,
you have to
it's
take care
not
of
your
too.
area of
Right.
expertise, but I'm going to ask you to manage that. So instead,
Right.
I have a trust set up. The bank would manage all those funds for my sister. Income would be created by that money every year. That would get paid out to my sister. She could use that to help raise my son. Then, when he became of age where he's going to
Mhm.
college, she could have discretionary distributions for education expenses, health expenses, maintenance and support. And we have experts who know what those standards are and can apply that properly. And then
Mhm.
when he turns 25, he would get a chunk, 30, he gets a chunk, and hopefully by 35, he could manage that where he's going to get the residual amounts.
Right.
Right. But that's another way I look at it. Just
Right.
there is a burden when you're asking someone who doesn't do it every day
Mhm.
to step in and act in those responsibilities.
Mhm. Well, it's freeing up your sister to really do what you want her to do, which is care and provide for
Absolutely.
your son. And if she had to do all of those other things, she's balancing all of that in addition to it. And so it really allows her to focus on what you would want her to
Absolutely.
focus on.
Yeah.
Yeah. Now, you mentioned, Matt, that a lot of institutions are kind of stepping away from serving in a fiduciary role, which is what our office has experienced. One of the reasons why I wanted to talk to you and do the interview for our clients is because there's less and less organizations that are willing to serve in a fiduciary position. Why do you think that
Liability.
is?
There are a lot of legal cases
Okay.
where trustees are getting sued or they're running into situations. Well, and I think it's kind of two parts. Number one, you have a lot of banks going through consolidation and they are pulling resources out of communities. So if you're expected to be trustee for someone who is 2 states away, how in the world are you going to go in and learn who this person is, what they care about, and be able to effectively provide those services? So what ends up happening is that they lag and don't do things that they should be doing. And then ultimately, there's a negative impact to the beneficiary. A lawsuit comes about, and the bank has to pay out money. And then they end up saying, you know what? We just wrote this $5 or $10 million check. We don't want to be in this business anymore. And they could just, but that's a big part of it is
Right.
they've stripped resources out. And so you don't have the people with that required expertise to be able to deliver those services.
Mhm. Which just I listened to my malpractice. We have to do CLEs for our malpractice insurance. And the number one area where we're seeing litigation is in the areas of trust and estates. It's the highest increase we've seen. So when we're thinking about naming a family member, it's certainly putting them in a position too where they could potentially be sued in their capacity as trustee. So having somebody like F&M that has more resources, more knowledge, can pull all of that together to really act in the best interest of those beneficiaries could be really helpful. And again, take off that burden from a family member that would otherwise be
Absolutely.
serving
And
in the
I think when we
position.
talk about it that way, someone could hear that and think, well, hey, my family members aren't going to act in a malicious way. And that's not the case, and that's not the case. A lot of times it's just lack of
Right.
knowledge and lack of experience with these types of documents.
Mhm.
I'll give you a good example. So I had a client who passed away and he left small amount of money in trust kind of for his three kids and let his brother as trustee of those assets. So 3 or 4 years go by after he passes away and the brother comes to me and says, hey, I'd like you to invest this money. I'm trustee, but I'd like you to invest these trust funds for my nieces and nephews. And so I get in there and start looking at it and I'm reading through the document. He had already distributed all of the trust assets to the one child, about half the trust to the second, and then the third hadn't touched it yet. They're all under the age of 24. And when I reviewed the document, none of them were supposed to receive any money outright until age 25. And then it was supposed to be in chunks until 35.
Right.
And, when I brought that up, he was like, oh, I didn't know that, just kind of, again, a lack of knowledge, lack of education on that
Mhm.
topic. And I said, well, I hope you have a
Right.
good relationship with your nieces and nephews, because honestly, they could come back and sue you saying, hey, dad knew that I was too immature.
For
Yeah,
not
I was too
following the
immature to
trust.
handle that kind of
Mhm.
money, and you gave it to me and I blew it. So it's not that they're intending to be malicious. A
Right.
lot of times it's just lack of knowledge and they want to be helpful
Mhm.
and they don't understand that there are
Right.
boundaries built into that
Right.
trust a lot of times for a reason.
Mhm. Well, another thing too is you used the phrase earlier, you said health education, maintenance, and support, which is a legal concept. There's a lot of history as to what does that mean. So if we have a client that doesn't have that background, they may think, oh, well, I can just distribute for whatever I want. But we have case law, we have statutory law that guides us so that we know legally what actually falls into health education, maintenance, and support. So when you get somebody like F&M that can be in that position, they know because they
Absolutely. And
do it all the
I had
time.
one time I had a trust beneficiary get really upset about just, again, that exact misunderstanding. She had
Mhm.
submitted about a $60,000 request to revamp her kitchen. And we rejected it because the terms of the trust
Mhm.
document did not allow that. And she came back and she said, I don't. So we got in this kind of heated exchange. And she said, right here it is, maintenance. And I said, that's not it's not house maintenance. That word has a different definition. And it's really meant to continue the style of
Right.
living that you had previous to the document being created. Right. So again, areas
Mhm.
where, and then after we explained it, she's
Yes.
like, oh, okay, well, that makes sense. But there are protections for a reason, and,
Right.
and those legal
Right.
definitions are there for a reason.
Right. And a lot of it
For
has
sure.
legal ramifications. A lot of times that language is used very specifically and strategically from a drafting standpoint because there are tax implications if you use
Yes.
other language than that. So I think too, if you're not somebody who's in the field, it just
Yeah.
looks like words on a paper. But when you start looking at the history and legally what each word is defined as under the law, it packs a bigger punch. And a lot of times, just a layman person that doesn't have that experience is going to do what your client did, where make distributions when they're doing it out of the goodness of their heart, trying to be very generous, but it just doesn't follow the guidelines of the trust. And that opens an individual
Exactly.
up
And
to
that's the
potential
last thing
liability.
anyone wants to leave in their wake is family members fighting or
Mhm.
litigation between family members. Nobody wants to leave that.
Mhm. Mhm. Why do you think more people don't know that F&M offers this service? Because again, I didn't know that until you and I had lunch and we've kind of flushed that out a little bit. Why is it that
Yeah,
we
I
just now
think
know this?
traditionally when you start talking about trusts, people think a trust babies, and they're thinking multi-millions of dollars, and you have to have this
Mhm.
extreme level of wealth for this to be a
Right.
consideration. When that's not at all the case, and there are lots of reasons to consider,
Mhm.
different types of legal structures. And as a bank, most people are thinking, "Hey, deposits, and I borrow money." They're not necessarily thinking about the investment part, and
Exactly.
it's becoming increasingly rare. Like I said, there's been a lot of consolidation in our industry, and
Mhm.
there just aren't that many still offering these types of trust services locally.
Mhm. I think that's the issue I run into. I had inherited a client from my predecessor, Attorney Maxwell, and in the will, they had named a bank. I won't say it's a local one, but I had named that bank as a trustee of a trust that was created under the will. And when the individual actually passed away and it came time for that bank to serve in the role as trustee, they went like this, hands off, not serving. And the reason they did that was because they said there wasn't enough money that was going to go into this trust for them to serve. Now, the issue that this kind of snowballed into is that there was no
Mhm.
successor trustee listed. So when the bank stepped away unexpectedly, then it left us kind of scrambling as to the trustee. So that leads me to two questions for you. So the first is that if F&M is going to be serving, do you guys want to see a copy of the document, even if you might be appointed at some future event, like not now, but when someone passes away? Is that something where you guys will review the document and confirm that, yes, you're
Ideally,
still willing to
yes, because if
serve?
there are certain things in there that might lead us to say, hey,
Okay.
that's not something that we feel we have the expertise to provide. I'll give you an example. So
Mhm.
there were a couple of years ago, when Trump was elected, there was a local individual that was being considered for a cabinet position. And so, as part of that, he was going to have
Mhm.
to put his business into a blind trust where it could be managed while he was in government. When that was presented to us, and I took a look at it, I was like, I don't have anybody that I on my staff that can run this business,
Mm.
right? So that was not something we wanted to be involved with. So there
Right.
might be, there are other companies
Mhm.
maybe that could offer that service, but it was not something I felt like we could effectively manage. So kind of a weird example, but there are times where,
Mhm.
maybe that we wouldn't want to be involved depending on the
No, I
assets, or,
think
or some different complexities there. It may make a different recommendation. Mhm.
well, and you would want so if F&M can't serve or they're not the best person to serve, it would be better, I know for my clients and I, for you guys to look at it and say, we're going to decline because this might be a specialized asset that we don't have the knowledge base for. Because if we go back to the fiduciary responsibility that you're supposed to be acting in the best interest of those beneficiaries, of those individuals, if it's not something that you guys have knowledge in, then it wouldn't be in the best interest of the beneficiaries for you guys to be serving in that
Exactly.
fiduciary
Exactly.
capacity anyway. So my second question, Matt, does tie in a little bit to like maybe some thresholds and situations of when you guys are able to serve. Do you guys look at it on an individual basis? Do you kind of have a number in mind as to when you're willing to serve and when you're not willing
Sure.
to
So
serve? Talk
first
to me a
off,
little
we
bit
have
about
no
that.
asset minimums. So there is no, hey, if your account's not a certain size, we're not going to be involved here. We do have minimum fees. And that depends on what
Okay.
capacity we're being asked to serve in. And, again, I apply that fiduciary responsibility, and we've been talking a lot about trust, but we have that same responsibility when we're just managing investments for someone. So our minimum fees range from $300 if
Right.
we're managing a group of mutual funds for an individual, and would go up to $2,500 minimum if we're managing a trust. So that translates into, assets
Okay.
probably in the $225,000 to $250,000 range. And you can kind of compare that. A lot of
Mhm.
our competitors are going to tell you got to have $2 million if you
Yes.
want to set up a trust with us, right? And especially, yeah, special needs
I
trusts,
was
you're
going to
talking 5
say,
million. So
yes.
our minimums are much
Mhm.
lower because this is
Yes.
our community. We know there are not a ton of people walking around with $15 million. We want to be able to serve and work in the community that we have.
Mhm. When you told me that there weren't necessarily asset minimums that you guys needed, but that, you kind of looked at it in a holistic approach of, are there enough fees for us to be able to maintain this in this fiduciary position? Couple of things. Number one, I think that's great because the last thing I want to do is have somebody in there that's only going to be able to serve on a short-term basis. So again, it goes back to the fact that you guys are looking at it through the eyes of a fiduciary and saying, yes, we're in it for the long haul, we'll be serving. And as a result of that, we're thinking through what does that look like payment wise, for you guys, because I don't want you guys to serve and a client's not going to want you to serve if after a couple of years you guys are like, well, we're done now because we can't take a fee. So I like that you look at it up front and kind of think of the long-term effects of that. The other thing I wanted to mention is those of you who are watching this, the fact that Matt said about 225,000 to 250,000, that's a low number. Like Matt said, a lot of times it will be a million plus in order for an institution to serve. So I was thrilled when you said that because I don't think people recognize what a big deal that is, especially here locally. If another bank or another institution has a minimum, for example, that example I said previously, their minimum is $1 million. So they wouldn't serve in the role of trustee. So when you told me that, I was like, that's amazing. That's a low number. That's a number that we see clients with that we can work with. So I just wanted to lay that groundwork because sometimes when you hear numbers, you may not appreciate what that
Yes.
means in the context of the whole business and how you guys are really kind of
Yeah,
stepping up
and
and
I'll add
serving the
to that,
community in that
especially
way.
when it comes to being financial power of attorney. So we have a lot of clients who, through
Mhm.
living longer, end up in a nursing home situation, right? And those expenses, especially for the highest level of
Yes.
care, can really become exorbitant and get to the point where it drains all of your assets. And you may sit back and say, hey, as a fiduciary, yeah, it gets below a certain level. A
Correct.
lot of people will back out and not want to be involved. We are not going to abandon our
Mhm.
clients when they need us most. So we do have many individuals who have drained
Mhm.
all their assets, but we are still paying bills on their behalf and working with the nursing home to ensure that they're receiving the care that they need. But that's not something where we're going to walk away when it drops below a certain level. We're going to continue to uphold that responsibility.
That's wonderful. Mhm. Yes. Now, I know you mentioned we hadn't come right out and said it, but F&M will serve as an
Absolutely.
agent under a
Yes. And,
financial power of
give you
attorney if
examples, some of
needed.
the things we do under that responsibility. I had an
Okay.
individual that we got involved as financial power of attorney after she had 4 different family members abuse that privilege. Um, and so we got involved, and she required a higher
Oh.
level of care, started to have some memory care issues. I got involved in listing and selling the home.
Mhm.
She had
Mhm.
her husband had spread around CDs to about 12 different
Mhm.
banks. So we consolidated those investment assets, got her into a facility that provided the care that she needed, and we invested that money to provide the income needed to pay for the care, but then also maximize the growth there for the next generation that was going to
Mhm.
inherit those funds. So, yeah, we get involved. We get taxes done for our clients. We do kind of the whole thing. Super nuts there. Mhm.
That's amazing. Yes. Well, and the fact that you guys are wealth managers too, that can be really helpful, like you said, to be able to grow the trust assets, or if you're serving as agent to grow
Yeah,
that
and we
client's
have that
assets as
fiduciary
well.
responsibility again when
Absolutely.
we're making those investment decisions to select what's in the best interest of the
Mhm.
client and provide look at all the parties that are involved that are going to benefit from this money and make sure that we're maximizing it for all parties.
Mhm. Mhm. I know we've touched on it, but I think that I just want to come right out and state some examples of when having somebody like F&M serve as an agent or as the trustee would be really helpful. So I'll throw out one example. I had a family that had 4 kids, and although they had some trustworthy kids, the kids themselves did not get along together, the 4 children. And we were doing a trust because they had some farm property and some liquid money. And we were considering, do we want it to be a configuration of the kids? How do we want to work that? And we ultimately came to the conclusion that it would be better if we had a non-family member, a non-child serving in that role, not because we didn't have trustworthy kids, but because of the dynamic between the children. Sometimes you may have a trustworthy child, but you don't want to put them in the position where if they don't get along with a sibling, that you're setting them up to potentially have litigation or have to deal with a child that may be disagreeing. So that I would think would be an ideal time where you're looking at somebody like F&M to be able to serve in that position. What situations do you see? I know you had mentioned before some. Are there any others that you can think
No, I
of,
think
Matt,
those
as
are
to
some
when
great
you would
examples,
want
right? We
F&M
talked
to
about
serve?
where there would be a burden laid on a family member for acting in that capacity. We've talked about, different types of trust.
Correct.
We didn't really
Mhm.
talk in detail about special needs trusts, but there are a lot. Yeah, let's talk about that because those have
Let's
such
talk about
special
that for a second.
requirements, right?
Yeah, because that's what I was going to say. The other reason that I see that you might want to have a corporate fiduciary serve is because special needs trust can be very complicated to administer. So the concept legally is that you're putting assets in the trust so that the individual can still qualify for whatever government benefit they're on. So it might be SSI, might be SSDI, it might be Medicaid. And there are financial thresholds that we have to be aware of. And then inside the trust, Pennsylvania has some pretty strong language that says, especially if someone's on SSI, that the trust assets can be used to supplement, but they cannot be used to supplant that benefit SSI is paying for. So when we have, a lot of times it might be like a sibling or a family member, they don't really understand what SSI is designed to pay for, and they don't really understand when can we make a distribution and how should we make the distribution. So I had a client that actually was making direct
Mhm.
distributions to the individual that had special needs. And by your face, we know that's not the way we do it. We don't make a direct distribution. And so to me, special needs trusts are a great time for you to have a corporate
Absolutely.
fiduciary
And kind of
serving
the
because it is very
unintended
technical.
consequence there is you can end up subjecting that entire trust to having to be spent down to zero before the state will come in and
Mhm.
reinstate those benefits. So, yeah, it takes such an incredible level of expertise, not only
Exactly.
in trust law and kind of the administration of trust, but you've got to understand all those government programs you've laid out. And the average person is just not going to be able to stay on top of all that
Mhm.
and make those distributions in a way that it doesn't subject it to being included and into the state disqualifying it for that special needs treatment.
Mhm. Yes. Even something as simple as I talk to clients about how,
Mhm.
we can do a credit card where we can make charges or purchases and the special needs trust or the supplemental needs trust can pay that credit card bill. But you want to make sure to the extent you can to title the credit card in the name of the trust. And again, when you're making charges, especially if the individual's on SSI, you don't want them to be charging for food because that's one of the things SSI is designed to cover. So when you start charging things that would be food, then again, they're potentially jeopardizing the assets in the trust to have to be spent
Absolutely.
down in
And
order for
we've
that
done the research.
individual to
We have
maintain those
vendors that we
benefits.
use if we need to pay an hourly employee to come by the house. I mean, we have kind of the structure in place to be able to provide those services and do it in such a way that it complies with those state laws.
That's wonderful. That is, I think, a missing service that we haven't really had in the area, because I see so often where family members will say, well, if it's 2 kids, we'll have our other child serve as the trustee. And it's just, again, they don't need the burden of understanding what benefit and what it pays for and what can we make distributions for. And talk about the guilt they would have if they made a distribution for something they shouldn't have made,
Absolutely.
and then it puts the whole trust
No, and
at
then,
risk.
a lot of
I
times
can't
those
even
trusts, if they're set
imagine.
up correctly as a
Yeah.
third-party trust, you're expecting those assets to carry through and go to other beneficiaries,
Mhm.
whether it's, grandchildren or maybe the other child at some future date.
Right.
And yes, if those plans were to get ruined just by an oversight, that would be horrendous to live with.
Mhm. Mhm. And do you guys serve, is that the most often used trust that you guys
It
serve
has
as
been
a
actually our
fiduciary
fastest
for, or
growing
special needs
area.
trust?
We hired, yeah.
I bet, Matt, because
No, it
this
is,
is
and
huge. Like,
if
I
you
don't think
start
people
going around our
understand how
local
huge
area,
this
I know
is.
there's a lot of discussions about building kind of a division of leg up farms up around the Penn National area. So I've been involved in some of these discussions where you have people from the
Mhm.
community coming in, and
Mhm.
you start to learn how many people have this dynamic in their family, and they just don't have any place to find these
Mhm.
services. And yes, to your point, I mean, there aren't many people around who have $5 million to
Mhm.
put into one of these trusts for the benefit of one of their children. So it is an area, and like I said, we've brought on some additional staff members so we can be able to provide these services at a high level. We actually have an
Mhm.
individual who joined us from Wells Fargo here in the last 3 years. She's my counterpart, works up in the Harrisburg area, but she got us listed on a kind of a short list out with the Orphans Court in Philadelphia. So when you do have these types of situations, a lot of times we're getting
Mhm.
that business because you have families. Maybe there was a car accident, and you have a child who's disabled as a
Mhm.
result, and there's a settlement. We're getting very involved in those types of relationships. So we've been able to build
Mhm.
out the vendors and the other infrastructure to be able to provide that highly complicated
Mhm.
planning need.
Mhm. Okay, that's great to know, I think. And again, such a service to our clients in this area and the surrounding
Absolutely. And
areas that you
kind of
guys
on
are
that same
willing
topic
to
of
serve
different
in
areas
that
where we
role.
see a lot of opportunity where we're getting involved a lot, certainly on the financial power of attorney end. When you look at our local community, we do have a lot of people moving here from out of the area
Mhm.
due to the preferential tax treatment of being retired in Pennsylvania. But
Yeah.
we also have people who grew up and live here, and I heard one of our local
Mhm.
representatives speak on this topic before. I don't think we do a good job. We raise our children here, they go to college here, and then they move away, right? So to find their career
Mhm.
path. So your
Mhm.
kids who you may want to act as financial power of attorney, they may
Mhm.
live 2, 3 hours away or a plane flight away. So how are they going to be able to adequately get involved and be checking for
Mhm.
your bills, getting those things paid, and manage those finances from afar? That's again kind of a big
Mhm.
ask. And you talk about laying those responsibilities on family members. It's very tough to do that from a distance.
It is, and it gives some checks and balances, because maybe you have a medical power of attorney where you want to name a child. But again, checks and balances, you could name a fiduciary, corporate fiduciary, to serve as your financial
Absolutely.
power of attorney to
Yeah,
provide
and we
those
would
checks and
provide
balances.
annual
So I think
statements
that's
to other
important.
family members. I mean,
The
we
other
want
thing,
somebody to be looking over our work on an annual
oh,
basis and say, hey, if
perfect.
there's something here that you
Yes.
don't agree with, voice it. Right. So
Mhm.
so we will provide that documentation.
Right. Absolutely. An interesting nuance is that in Pennsylvania, you can pay a caregiver child if you have a caregiver agreement in place, but that child cannot also serve as your agent under the financial power of attorney, because the state looks at that as a conflict. So again, you could have a situation where you have a child who's coming in and providing care and you want to pay them under their caregiver agreement, and that would be the child that you would pick as your agent under the financial power of attorney, but legally you can't do that. So having somebody like F&M serving in that role would allow you to still have that child be paid as a
Absolutely.
caregiver and not be violating the Pennsylvania rules. So that's another, and again, that's a very specific example, but that's another example. I also am seeing more and more people that maybe haven't had kids. Maybe they've made the decision to not have children. And so I know that I have a couple of clients that have asked me personally to serve as their power of attorney. And I always struggle with that because I feel like I am best serving in the role when I can act as your advocate and your attorney. And so I would love to be able to have somebody that's not me serving in the role as agent. And I feel like F&M would be a good option there to be able to serve, because then that allows me to do what my job is and be able to really advocate while we have somebody that's handling the finances. And I think that's another great example of when
Absolutely.
F&M
And I know we kind of touched a little bit on the fee end of the spectrum, kind of with minimum fees. What are actually the management fees we charge? And so when you're talking about a trust, the larger the amount of assets we're managing, the cheaper it is per dollar. There are break points that are involved there, but just for generic conversation, for a trust, we're around 1.25%, and then it works down from there based on the size. If we're just managing money for you, that could start at 0.9% or 1% or right around there. So it is not a massive premium that we're talking about here to have us involved in a fiduciary capacity. And I view that's, truly where we bring the best value for our customers when we're acting in those additional capacities.
Absolutely. Yes. And just to kind of provide background, um, part of my job is to keep track of like what's happening across the state as far as trustees fees. The fact that, you said 1.5% or whatever, and it could be lower than that. That's a phenomenal fee, honestly, because we see other companies charging much higher when they're serving. So they'll have a larger minimum amount and they're going to charge more than that. So just so everybody has the context of knowing that that's a very low
and that's
fee
we
when you're
review
looking
that
at
too,
what
right? Because
other
we want to be aware
institutions
what everybody
charge.
else is charging. So you're starting at 1.25%. I mean, I see other competitors that are starting at 1.75% or even close to 2%. And again, like you said, much higher minimums and higher break points to be able to get any reduction on that.
Yes. I tell clients, if you're going to name a corporate institution, you be prepared that it's going to be 2%. So if you can do less than 2%, then you've really picked a fiduciary that is going to really maximize,
you want to
I guess, the
structure it in
bang for
such a
your
way
buck
that
that you're getting.
the clients and the beneficiaries win. Also there's got to be some compensation for the liability the organization takes on. But if you're taking the majority of the return and fee, that's not in the best interest of the customers.
Right. Right. So it goes back to that fiduciary responsibility, how seriously you guys take that when you were trying to act in the best interest of a client. So we talked about special needs trusts, but there are a whole host of other trusts. Are there any trust documents that you guys, when you review the instrument, maybe don't want to serve? Are you guys willing to serve
being
for
a
like a
community bank,
charitable
we're
trust?
very involved. We encourage all of our employees to be on boards of the local charitable organizations. So no, a very large portion of our business is charitable trusts. Everything from, the trust that we've managed for, I bet 65 years that pays out scholarships to local youth in the Montalto area. So there are a lot of those that we manage. There's nothing that we would be, shying away from on that front. And as well as I, when you're involved in kind of that estate planning, financial planning, when someone says charity, there are all sorts of nice strategies that you can employ to minimize taxes and to do a variety of things. It kind of gets us excited when we hear someone has charitable intent.
Yes, but it's also very technical. It reminds me of a supplemental needs trust in that charitable trust or another trust where it makes sense to name a corporate fiduciary because there's so many strict requirements of making the distributions and making sure you're following the IRS guidelines. So the fact that F&M, that makes sense to me that you guys serve in that role because again, a person that doesn't have that background isn't going to understand some of those requirements. Plus, I bet you guys probably have a great internal system that tracks when you have to make certain distributions out, because there are a lot of times where charitable trusts, you calculate something at the beginning of the year, the percentage that pays out is based on what the value was in the first quarter, but you don't pay it until the end of the year. So you guys would have all of the
Absolutely. Early
mechanics to be
June,
able
I
to
get a
make
copy of
sure
the
that
990
happens the way
PF
it
for
needs
all
to
of the
happen.
charitable trusts that I have. And if we have to make an additional distribution or if we overpaid, you get those adjustments. Also, it gives you the opportunity, to what degree do you want to leave that charitable legacy with your family? Do you want, yeah, do you want your family involved?
That's
Yes.
what I was just
And
gonna
you probably don't
say.
want them
Yeah, you
maybe
want
having
it
the
to
responsibility of
last.
doing all those nuts and
Mhm.
bolts things with it. But as far as choosing the charitable beneficiaries and being involved in seeing that money go and to do good work, a lot of times that's how we get involved. Hey, we'll run the back end, we'll manage the money, we'll invest it,
Mhm.
we'll do all the tax filings, track how much money needs paid. But then we have the family members come in and they say, well, hey, here's, dad died of cancer. So we want to benefit this, maybe that's Penn State's dance marathon, to see that, children with cancer are taken care of. They get to actually get in and decide who are the organizations that benefit from this legacy.
Mhm. Well, and when I think of a charitable trust, you're thinking of that lasting legacy. So hopefully the funds are going to last past a child's life. So if you're appointing a child as a trustee, obviously they're going to pass away at some point. So having an institution in that role provides a lot of stability to make sure that that legacy is being fulfilled year after year. So I think charitable trusts are a great way when you're thinking of a fiduciary, a trustee. It would be a great place to use a corporate
Absolutely. And,
fiduciary,
we're
because
talking a little
then
bit
you
about
can
private
create that
foundations,
legacy
but
that you
certainly
want.
charitable lead trust, charitable remainder trust will get involved with any sort of charitable planning. Again, it excites us because there are so many tax benefits to setting up those vehicles.
Mhm. Mhm. Yes. Yes. And I am seeing more and more clients turn to that, because as we look at maybe what's going to happen in 2025 with the income tax sunsets and the federal estate tax sunsets, more than ever, I'm seeing clients turn to charitable things that they want to make sure they're fulfilling. And so I think too, we're going to see a rise in charitable trusts, which hopefully means a rise in you guys
Absolutely.
serving
I
as
mean,
the
there are a lot of
trustee
people, when they
if needed
passed
in
the Tax
those
Cut and Jobs Act,
situations.
you had that doubling of that estate tax exemption. But as we roll into 2025, they're going to be debating that again. And I
Mhm.
sat through a conference here recently, and I thought the guy put it very well. Is
Mhm.
that when the tax,
Yes.
when they're debating tax policy, everything's on the table, and anything could get changed. So we don't know. It's
Mhm.
certainly quote
Mhm.
unquote rich people are a target, right, for tax
Yes.
revenues. So we don't know ultimately where that number is going to
Mhm.
land.
Yes.
It's never been reduced. Doesn't mean it can't be reduced, right?
Mhm.
That's right.
But right. We've never had it this high before. So I guess maybe I land on the side of it's never been reduced, but we've never had an exemption that's been this high before. And, the money has to come from somewhere. So if it's sunsetting, it's an easy thing for
Absolutely.
them to do
No, I could
nothing, and
easily
it's
see
just
them
going
just
to
doing nothing and letting
automatically
it
be
revert.
reduced.
But you've heard some crazy tax policies proposed out there too. So
Yeah.
charitable strategies get us around a lot of that.
Yes. Yes. Mhm. Yes. Well, and a lot of people don't realize that, yes, you and I currently are talking about the federal estate and gift tax exemption, but the income tax rates are scheduled to revert back to what they were in 2017, which means that the highest tax bracket goes from 37% to 39.6%. So even the income tax rates are going to change if nothing is done. And a lot of people don't realize that you're going to see a jump. You might change a bracket, because the brackets are changing a little bit too. So very successfully recently, I had a client who they had a traditional IRA that had a lot of funds in it, and they want to convert it to a Roth. And what we did is we converted it to a Roth at the same time they made a gift into a charitable lead trust. And so we got a corresponding income tax
Absolutely.
deduction to offset the conversion from the
Yeah,
traditional to a
and
Roth.
Roth money
And so again, we're seeing a lot more of
so
those
great because
creative
you
plans.
don't have to take an RMD off of it. It grows tax free. You leave it to your kids. It can grow another 10 years after that.
Mhm.
it's the best money. Your kids would love to inherit that money, right?
Yes.
So yes, any planning strategies to get more money in Roth always have a tremendous
Exactly.
benefit.
Yes. Mhm. Yeah. So again, just another example of why we've seen charitable trust increase
Oh,
because
for sure.
people are
And then it
wanting to
gets
take
back to, some of the
advantage
more
of
basic
some of
things we
those
do, like
conversion
beneficiary
strategies.
designation. So your kids would love to inherit your Roth money. The last money they'd want to inherit your traditional
Yes.
IRA, especially under how those rules have changed, right? So they have to take out all that money, pay
Oh
all
my
the
goodness,
taxes
you're
within
right.
10 years, plus
Yes.
possibly continue RMDs. That can be a great way to leave that charitable legacy. I
Right.
guess the only downside I've seen is you
Mhm.
don't know exactly what's going to be in there at the end of the day, right? So that can be tough to calibrate.
Right, right. Yeah. But when you have good advisors that are meeting with you regularly, you can always adjust those designations. So if it's something where you want to increase or decrease the percentage, what I tell clients is you don't need me as an attorney for that. You don't have to change your will. You can meet with your advisor and adjust those designations as frequently as you want to. And so it is a great way if somebody's charitably minded to allow them the flexibility in their estate plan without
Absolutely.
having to
And I think
change
we've
their will
highlighted
every time they want to
why
change
this
what's going to
knowledge
charity.
around the estate planning topic is important for not only your attorney to have for sure, but also your
Mhm.
financial advisor so that they're able to navigate these and say,
Mhm.
oh, you're changing this. Do you know that's going to impact these three other things you
Yes.
did in your estate plan? I think it's really important to have everybody on the same page and understanding what that strategy is.
Mhm. So let's talk about that a
Yes.
minute.
So
F&M
we've
Trust, do
recently
you
gone
guys
through a
serve as
rebrand to
financial
Wealth
advisors?
Management is what we're calling our department. And so we provide everything from high
Okay.
level financial planning to at the low end, if you're just trying to open up a 529 for your grandchild, we can do that too, right? So we will run the gamut of services there, but we do partner with
Okay.
eMoney. We have ways to provide very high level financial planning and pull in your estate planning attorney, certainly pull in your CPA and have everyone be able to view that plan, see how we project those assets to
Mhm.
grow. Again, as we're developing estate plans in someone's 60s, but they may live to be 95. And if they're not
Mhm.
taking much money out, you might have not have estate tax issues at 65, but you
Mhm.
may have them at 90, right? So I think it helps you and other professionals to be able to deliver better advice when you can see
Yes.
how we project those assets to move. Yeah,
Yes. I love the team approach, right? Because I focus on one piece of that. But if you can have other professionals come to the table where they're focused on another
oh,
aspect
for
of it,
sure.
I
And,
always
and, it,
feel
and it
like the
extends
client's
beyond that.
going to
I
get the
had an
best estate
individual.
plan that way.
Again, we think about these things and everyone thinks, well, again, millions of dollars, right? But I had an individual who her husband passed away. There was enough life insurance. They paid
Mhm.
the house off. There was, probably around $300,000 left over and still had some young children in the home. And she did not have a very high income. So she was receiving benefits from the state for health insurance. And so we wanted to be very careful with how we invested these life insurance proceeds that we didn't create too much income that she lost these benefits through the state. So
Right.
I have a meeting, I just had it last week, where we sit down with her
Right.
CPA. We look over her income taxes. We invested her money in ETFs and did some things so it doesn't create much income, and then we'll review it.
Mhm.
And when we reviewed it this time around, she was going to have to pay in, and then also there was an extra premium for health insurance that she was going to have to kick in. So we review it this time of year because we can still make a traditional IRA contribution. So we'll review it and play around with the numbers with her CPA to say how much traditional should we do, and then
Right.
how much Roth can we do to better this situation so she doesn't have to pay more premium in. And
Mhm.
again, reinforcing your idea, it's so much better when everyone's on the same page and working together.
I love that. Mhm. Mhm. Yeah. All right, Matt.
Yeah,
So I just want to make sure, like with bullet points, you guys will serve as agent under financial power of attorney. You'll serve as the
or
trustee under
co-executor.
a trust
Yes.
document.
Mhm.
Executor, will you guys serve as the executor? Okay. Very nice. So you guys really have a whole host of services, and that's just talking about the fiduciary roles that you guys play. Like we already touched on, F&M also will do the financial advising as well, or wealth management. I know you said wealth management. So yeah, so that makes it really nice that you can have a team approach. Now let's say that somebody is listening to this, they didn't realize F&M
I would reach
offered
out to
these
our
types of
department.
services.
You can either
What's
go check
their
out our
first
website,
step? Who do they contact?
fmtrust.bank. Is our website. You can find some more information out there, or give us a call. Phone number for our main office, 717-264-6116. Tell them you want to set up an appointment with the wealth department, and we'll get somebody in touch with you to sit down with you.
Okay. Now, if somebody's hearing this and they're thinking, maybe I would want F&M to serve as my agent or as the trustee of my trust. Is that something
They
that
would
they
reach
would
out to us.
contact that
And I know we
same
didn't maybe
number
get
in
a chance
order
to
to
dive into
do
that a little bit,
that?
but if you have legal documents you want us to act in a capacity, we love the ability to review it in advance and just make sure we feel that we can, act in those capacities. And if there was something we're like, oh, we don't know about
I love
this,
that.
love to be able to kind of share that
Yes.
and see if that's something that
Yes.
could be adjusted, or if maybe we're not the right fit.
Mhm.
So yeah, absolutely. We have a fiduciary review committee that meets weekly. So if someone has legal documents and wants us to act in that capacity, we would review those at that time, and we'll,
Okay.
if we like it, we'll sign it and send it back to you.
Mhm. Mhm. And I'm sure that you guys get a lot, maybe, hopefully, through attorneys that might say, hey, here's a client that might want you to serve in this
Absolutely,
capacity, and
because
kind of
we don't write legal
making that
documents, right?
referral
We are
to you
going to
guys.
partner
Do you
with
get a
attorneys
lot
to
that way
provide
as
those
well?
services. What we are going to ask you is to make sure you have those legal documents.
Mhm.
And then we're going to ask you, who are the people serving in those
Yes.
roles? And, I can give you great examples of where family members have done fantastic jobs, and I can give you horror stories.
Mhm.
And it's just, looking at your family and saying, do I have people that want that responsibility, can
Sure.
handle that responsibility? Or is that going to create family dynamics issues?
Mhm.
Again, the last thing anybody wants to leave is family fighting or arguing over money in their wake.
Right. Right. I always think that too when we're talking about executors. Are you leaving it so that that individual is going to be having to
No, and a lot of times,
deal with a lot
we'll
of
meet and we'll
conflict?
talk with
Nobody wants
clients
to set
who
their child
a
up
brother
for
or a sister
conflict.
settled mom and dad's estate, and they still view that they did something they shouldn't have, and they kind of harbor this resentment over the years, and they'll explain the situation to you, and you're like, no, they did exactly what they were supposed to do.
Mhm.
But again, it's that lack of knowledge, lack of understanding. And for us, it's, hey, if they're going to be mad at anybody, don't make them mad
Yes.
at each other. They can be mad at us, right? So that we can step into that role. Exactly. Exactly.
Exactly, right? You guys can be the bad guy. Okay, I had a list here. What
I feel
else
like
am I
we've done a
missing,
pretty
Matt,
good
that we can
job
talk
of
about? Was
touching
there
on all
anything
of
else
it.
that you wanted to
We
share
touched
today that we
on
haven't covered?
kind of the different ways that we can serve. I think maybe Guardian is one that we didn't spend a lot of time on. Yeah.
Mhm. Let's talk about that for a second. Yeah, let's take a minute and talk about that. So, I know I have to deal with the guardianships a lot where somebody hasn't done a power of attorney, right? And they've lost capacity. They don't have the ability to appoint a power of attorney, so we need a guardianship. But I've also seen it in situations where the person never had capacity, right? It could be a child that has special needs that is never going to be able to sign a legal document of any
Those two
kind
and
appointing
minors.
anybody. Are
If you have a
those the
minor
two
child
situations that
who's,
you're talking about when we're
yeah,
talking about a
until they
guardianship?
reach the age of majority there,
Okay,
that
that's a
will
good
continue to
point.
manage
Yes.
their finances
Hmm.
for them. Yeah. And that, again, that can be done through a trust, but absent it, a lot of times we
Okay.
get involved that way. Or in,
Okay. Sure, because in Pennsylvania, you don't have to have a trust. You can actually name a custodian who can serve up until the age of 25, and there's no trust requirement in PA.
Absolutely.
So that
Certainly,
would be
we always
something that
recommend,
you,
please
F&M,
do the
could
power of
serve in
attorney
that role
documents,
as a
right? And,
custodian if
one
needed.
horror story, I'll just real quick. We had two clients kind of out in the Fulton County area who They were getting into
Right.
their 90s. Wife, unfortunately, had come down with dementia and had to go into the nursing home. And husband said, "Hey, I want to move in with her." Problem is, the vast majority of their assets were the family farm, and he was going to be required to sell that to have the assets to move in with her. So had to go through that entire court proceeding, and it took, I think, 7 or 8 months to get him awarded. Yes, it is not a
Mhm.
process you want to go through. So finally, he gets awarded,
It takes
power over
forever.
her
Yes.
finances,
Mhm.
and sells the family
No.
farm. He moves in with a nursing home with her, and he passed away 2 weeks later. So it's like there's 9 months they could have spent together had they just had, taken some time to draw up those
Oh,
legal documents.
oh my
So
goodness.
always something we're asking about and we're encouraging and trying to be involved in promoting.
Yes. Yes. The other thing to think about is the timing. Of course, your example is a great example
Sure.
of what you miss out on when you don't have it. There's a monetary component to it too. So if you do a power of attorney, it's
Absolutely.
$250 or $300 to do a power of
Yeah.
attorney.
Yeah.
It
And
could be
again, you get
thousands of
involved where
dollars
doctors
when
don't
you're
want to be
having to
the
go through all
ones
those
who,
court proceedings.
because you lose the power to do a lot of things when when someone's awarded as your guardian. So doctors are
Right.
very resistant to it. It just takes forever and you have court costs. You're
Mhm.
absolutely right.
Yes. 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 The other interesting thing before we leave the guardianship topic is Pennsylvania just recently did an overhaul to their guardianship filings and requirements when someone is appointed. So it goes back to if you're an individual person that doesn't recognize that there are certain background checks, certain filings that you have to make when you're serving as a guardian, you could inadvertently make a
Yeah.
mistake. And that's why
Annual
having a
accountings to the
corporate
court. I mean, we have to
institution
go in there
serving
and
can be
file
really
those.
helpful
So,
because they know all the
yes, and
rules.
that's a
They do it all
requirement
the
for an
time.
individual as well. And you can get in some trouble if you're not doing
Yes.
it because the court wants to see what you're doing for this individual. They are a ward of the court.
Mhm.
The court wants to watch out for them.
Yes, absolutely. Yes, absolutely. Yes. I'm glad we did talk about that a little bit because we're seeing more and more of that if people are not doing powers of attorneys or maybe we're never able to do
I don't
powers of
think so. I
attorneys. So I'm
think we've
glad we
done a good
talked about
job
that. What
of
else
covering all
should
the
we
different
cover
ways
today,
we
Matt? Was
serve.
there anything else you had on your
I
list?
think what I really wanted to leave is just the importance of the partnership between all the people who are providing those services to
Yes.
you. And again, needing fiduciary
Mhm.
services is not something reserved
Yes.
for people with millions and millions of dollars.
Yes.
You know, taxes are one reason, but there's certainly family dynamics
Mhm.
and other needs that drive those decisions. So
No.
don't be nervous about speaking with someone about these
Mhm.
topics just based on the fact that you don't think you have
Mhm.
the assets for it to be concerned with it. Because I think we've highlighted a lot of
Yes.
circumstances where there are great benefits.
Mhm. Yes. Mhm. Well, I think what I've learned from this conversation, not that I didn't know it before, was that as part of the triaging where I'm talking to clients and talking about their estate planning documents, I think I'm going to start asking families, have you considered a third party serving in that role? Just because I don't know that people are thinking of it off the top of their head. And so just from this conversation, I feel like that's what I've learned is that we need to at least ask the question, even if the question is, no, I have a child and I want them to serve, thinking through that now that we're in this situation where a lot of kids aren't here locally, we see
Yeah,
more spreading of the family out
yeah.
over
I think a
larger
lot of times it's
distances.
just a knee-jerk
It's
reaction.
definitely worth
Okay, I'll
having a
choose my oldest
discussion
child, and there you
about
go,
with
right?
our
But
clients.
and, yeah,
Mhm, mhm.
yeah,
Or I
and it's not
have to
that
choose
way.
them.
I
I
think
get
you
that
do
a
have to
lot.
play that
I
out and say,
have to
okay,
choose my
let's think
oldest
about that.
because
When we
they're my
pass
oldest.
away, have these children
Mhm,
interacting and trying to settle the estate. What's that look like? And
mhm.
do you leave some strife and
Yes.
complicated family dynamics by throwing it into one of their laps? Or if there's two or three or four of them that have to agree on something, that can create its own
Mhm,
issues, right? So you got to play that
mhm.
out and say, is that going to make sense down the road,
Mhm.
or are they going to be able to act as my
Yes.
power of attorney? I think it's something that needs to be thought about for sure.
Mhm. Yes.
Absolutely.
Yes. And I think that the most important legal document you can have is a financial power of attorney, because I think that you're still living, right? This is a situation where you are still living, you just don't have the capacity. When you're dead, you're not really going to care. Yes, you want to leave the most amount, you want to put it in a situation in which you're setting everybody up to succeed, but my concern is always people don't think about the fact that with a financial power of attorney, you're still here.
I
So you still
totally
need
agree.
someone
More
to be
important than your
doing
will,
what's
more
in your
important than that
best
medical
interest. So I
directive.
think that's actually the most
Because,
important
a lot
legal
of people, it's a
document.
simple will. The state has a process, right? But power of attorney, there's no substitute.
Yes,
Well, the substitute is the
yes.
guardianship process, right? Which is onerous and
Mhm.
expensive. So, no, I'm more concerned
No,
about that one than any of the others, for sure.
exactly. Exactly. Yes, yes. Mhm. Yeah, and I know we referenced it, but let me go ahead and throw the number out. So if you would do a power of attorney and you're talking a couple hundred bucks.
Absolutely.
The last time I was involved in a guardianship, it was 5,000 plus to do.
Absolutely. And, as you talk
So
about
you're
power of
not
attorney,
going to
the other
get
thing to keep
away
in
with,
mind is whoever you
a couple
name,
$100
they
if you
have
have to
that
do a
power from day
guardianship.
one.
So,
Right. And so you got to play that out as well. Is that a family member or a friend or whoever that you want having that type of
uh-huh.
control? I've got a whole filing cabinet at work
Yes,
where we have power of
yes,
attorney documents where we've been written in, but no one has asked us to serve yet. So we have the power. We could act at any time, but we wait for you to tell us, hey, you know what? I think it's time. I need your help. Or a family member to
hmm
call and say, hey,
hmm
yeah, we had to put dad in a nursing home
hmm
and we're going to need you to act on in that capacity. So we're not going to step out of bounds unless we're asked to do so.
hmm right. I have two thoughts about that. Number one is I recently served as the power of attorney for a client who clearly still had capacity, and she was admitted into the hospital, and a doctor that was in Chambersburg did a psych evaluation via Zoom. So think about this. I have my little old lady client that's not good with technology. The doctor was not clearly speaking. It was hard for her to understand. She's hard of hearing. He had a thick accent, and they declared her incapacitated, which was such an unfair determination. I think right now, the crisis we're facing is that we're so quick to determine that a person who's aging does not have capacity instead of allowing them to make the choices and make the decisions as long as they're able to
Uh-huh.
do that. And so I appreciate what you're saying about that. I think my staff gets tired of listening to me rant and
No,
rave
that's
about
it.
that,
And
but I do
incapacity
think
is
it's an
not something that's
issue.
here
We're
one
so quick
moment
to
and
be like,
gone the
oh, they don't have
next. It is a
capacity. And in fact, they
process.
do.
Yeah, another client example, but I had one of my little ladies who
No, it's a
was in
fluid
the early
thing.
stages of
hmm
dementia, and when it starts, it's kind of like, hey, you have 6 good days and one bad one, and then that ratio switches to where you're having 6 bad days and one good one. But one day she showed up with two family members,
Yeah.
and I think this was a distant
Mhm.
nephew and his wife, and they said, "Hey, our aunt has decided she's going to buy us a house." And I was like, "Oh, okay, is that right?" And I looked to her, and she's like, "Well, I would like to help if I could." And I could just kind of
Oh,
notice from the look on her face she wasn't having a
oh,
good day.
okay.
So I said, "Okay." I said, "Well, I stalled." I said, "Well, hey, I'm going to have to investigate this, figure out how we'd structure that gift. Why don't we reconvene in a couple of weeks
Yeah.
after I'm able to do some research?" So they left. This was on a Friday. Monday morning, she calls
Mhm.
me at 8:01. Said, "Hey, I know we showed up there on Friday.
Mhm.
We didn't do anything, right? We didn't give them any money, did we?" And I said, "No, and thank you so much for calling because
Sure.
I was trying to stall so we would have time to discuss." But it is not a here one moment, gone the next. It's fluid, and
Yes.
that does not mean that person's not capable of making decisions.
Yes. Mhm. Mhm. Right. And sometimes people have better times
Mhm.
of the day. Like if I'm meeting with a client that has a diagnosis, one of the things I will ask is, what's the best time of day? Because maybe mornings they're the most clear, maybe it's right after lunch they're the most clear. And that's okay. We want to catch them at
Absolutely.
that
And
clearest
but
moment
same
so
token, you want
that
to be able
we
to get them
can
help when they
allow
need
them
it.
to
And
be
I know a lot
making
of people
decisions
might
as
still
long
have
as
a
they're able to
springing
make
power of
them.
attorney in their lockbox. And it's like, you do not want to go through that process of getting deemed incompetent. You
Exactly.
don't.
Yeah. No. No, it is not, it's not a pleasant experience. It's cumbersome. It takes a while. Like, you just don't want that.
Mhm.
And the other thing too, as we're talking about it, I have so many clients that don't have the powers that are needed in their power of attorney document. Like, they might need to update beneficiary designations or do certain planning for nursing home. And if the power of attorney doesn't have those powers in them, then you're
Yeah,
back to the
we've got
guardianship.
people in their
If you
70s
need a
and 80s on
power that's
Facebook. You
not
have
in
to
the
have those
document,
digital
then the
assets,
document was worthless and you have to
language
obtain a
in there as
guardianship.
well. Yeah. Otherwise, we lose the pictures, right? Facebook's not going to let us in without a document.
Thank you, Matt. Yes. Yes. I know. Yes.
Yeah.
Yes.
No, it's always a good time to get together
Yes.
with you, Sam. I
Yes.
appreciate
This
it.
has been so much fun. I feel like I could just talk to you all afternoon. I know. I know. Well, I thank you so much. So, everyone, just to kind of know, I will put in our description the contact number that Matt provided along with the website. So that way you can just click on it if you would need to do that. And I'll make sure to post this on our YouTube video. But thank you so much, Matt, for being on here. This was Partnering with the Pros. We had Matt Berger, who is a regional wealth manager with F&M Trust. And I was excited to
Just
have
thank you
Matt
so
because I
much for
know
the
him
time and
personally,
the
having
ability
gone
to
to
come in
school with
and
him. So thanks
talk
so
with your
much, Matt, for being
clientele
on the
and
call.
hopefully
Anything
share
that you'd like to close us
some
with?
knowledge that people found useful. So again, we are here to help, even if it's just for a conversation or seeking some advice. We're happy to help.
Yeah.
As a community bank, that's our role, right? So thank you so much and hope to see you again here soon. Thanks, Sam.
Yes.